Good afternoon, everyone, and thank you for joining us for this ILR Briefly live event. Before we get going, just a reminder about how we structure these. This is our second one. We'll do an initial conversation with our two guests, and then we're going to open it up for a few minutes of Q&A from the audience who has joined us today. In terms of how to ask questions, please just enter them in the chat bar that's on the right side of your screen. Hopefully it's on the right side of your screen, and we'll definitely address them towards the end of this discussion. We had a great Q&A dialogue last time, so in advance, I want to thank you for your contributions, because I'm sure that this is going to generate a lot of good discussion digitally as we use this platform. Now, we've held our first ILR Briefly event on April 1st. When we did that, the coronavirus and COVID-19, the liability issues surrounding that, was already making a huge impact, and since then, the impact is only growing. As many of you have read in the news or heard on CNN and elsewhere, these liability issues are definitely getting a tremendous amount of attention at the national level, at the state level. I'm sure you have heard the president's remarks just of last week, including the director of the NEC, Larry Kudlow. The administration is certainly looking at a number of these issues. Members of Congress, as they return next week, will be looking at these issues as well. The national business community, but including small and medium-sized enterprises, have also raised enormous issues surrounding the liabilities that could flow from the reopening of our economy. I will assure you, and many of you do know, that ILR is out front on this discussion. We have certainly spoken to the media at length in terms of what we think are the appropriate policies, that they should be narrowly tailored, that they should be timely, and that they should be smart solutions. And over the past month, we've convened hundreds of business leaders, expert practitioners, academics, and others to pool their expertise to identify the biggest liability challenges that's associated with the coronavirus pandemic. And as a parallel process to this, we've commissioned research from legal thought leaders on the most effective legislative and administrative solutions to keep businesses from being hammered with abusive or frivolous lawsuits. And at the very moment, they're hanging on for their dear life. And the last thing that they need as they are trying to make payroll, as they are trying to re-engage the economy, is to have the threat of litigation come their way. We will be releasing this research as early as tomorrow. And so consider today's event somewhat as a preview of what's to come. This is going to be posted on our website at instituteforlegalreform.com. And we'll make sure that every attendee who is RSVP'd for this event also gets a specialized link so that you could review this 20+ page paper. And just an additional word on this research that we are going to be talking about today. It is a comprehensive assessment of the liability problems that could flow from federal statutes as well as federal programs. It certainly captures the 4 core pockets of liability areas that ILR and the Chamber has identified early on, and that we've been discussing with our members, with our working groups, with the administration, and with Congress. These 4 areas include exposure liability, product liability, medical liability, and securities litigation. But we thought it was very important to elevate on a much more public platform some of the additional issues that are associated with this. And the research paper, as you will see in the next day or so, will really get into a good discussion, a good analysis about federal programs, about other statutes, and some things that the business community ought to be thinking about beyond these 4 core pillars, which we've identified at least up to date. So let's get on with the show. Let me introduce our 2 guests today. Many of you on this call know John Beisner. He leads the Mass Torts Insurance and Consumer Group Litigation Group at Skadden Arps. He is an institution in and of himself with regard to class action litigation, mass torts, product liability. I met John many moons ago when I was working up on the Hill on the Senate Judiciary Committee. He is considered the godfather of the Class Action Fairness Act, which was passed and signed in 2005, and a true thought leader when it comes to some of the major liability concerns that the Chamber and that the business community has been confronted with over the past several decades. So welcome, John. We are really thrilled to have you with us today. He's also the author of our latest ILR Briefly paper that I just mentioned, and so he can give some pretty good insight in terms of the problems and the solutions. The other speaker I'd like to welcome is Bob Huffman of Akin Gump. Bob is a veteran litigator and an expert on the litigation nexus between businesses and the federal government. He's an adjunct professor at Georgetown Law, and he's a real expert when it comes to things like enforcement under the Federal False Claims Act. So in other words, if you get a qui tam complaint that gets unsealed, you should probably call Bob because he'll have a lot of good insight to share with you as you navigate through some of those challenges. So gentlemen, thank you both for being with us today. Bob, I'm going to start with you. We talked about the 4 core pillars, and this is definitely occurring in real time as part of the advocacy. But early on, about a month ago, we were really focused on the legislation that was moving through Congress, the so-called Cures Act, which provided $349 billion in funding under this Paycheck Protection Program. Many of us here in the Beltway call it Phase 3. And this occurred roughly over 2 weeks ago. I will say in that legislation, with this Paycheck Protection Program, there was a specific program where lenders who are designated by the Department of Treasury can administer small business loans that were granted through this Cures Act through congressional appropriations. And it would be administered by major financial institutions. And there were a lot of concerns about the extent of liability that could flow from an enforcement perspective when it comes to the False Claims Act specifically, but also other federal statutes. We certainly raised these concerns early on with the administration. There was a rulemaking that occurred in concurrence with that. But I think a lot of the concerns were animated by what happened after the Great Recession in 2008 under the TARP program, the Troubled Asset Relief Program, where many of the financial institutions who received this funding ended up also receiving untold numbers of class action lawsuits and False Claims Act litigation. And so I think that concern carried over into this newly developed program, which, as many of you know, moved pretty quickly through the legislative process. So Bob, can you talk to us a little bit about some of the False Claims Act concerns that specifically emanated around the Cures Act, in addition to some of the False Claims Act enforcement activity that we've seen from the Department of Justice? Bob, I'll turn it to you.
Sure. Thanks, Harold. I think that as you said, the TARP program coming out of the Great Recession 08 really was in everybody's minds, including plaintiffs' lawyers, relators' lawyers' minds, when this huge program came through for the PPP program, Paycheck Protection Program, as part of the CARES Act. Because it's so much money and it was so urgent that the banks who were administering the program act quickly. And in light of that, I think the Small Business Administration and hopefully DOJ are kind of taking prophylactic measures to avoid frivolous or onerous qui tams and just direct DOJ FCA suits. So what the Small Business Administration did in its rulemaking is to come out and say that lenders would be entitled to rely on the certifications of the small businesses applicants for the loans and for loan forgiveness in granting and processing the loans and the forgiveness, and that they would be held harmless. That's the word the Small Business Administration used. They'd be held harmless for a applicant's failure to comply with the eligibility criteria. And this was aimed at the, as you said, the False Claims Act suits that were brought against lenders for failure to, quote, adequately do due diligence or other kind of reckless review of loan applications back in the 08 crisis, which really could be nothing more than the loans went bad or the eligibility criteria weren't ultimately met. So as you said, the Chamber and ILR filed comments applauding that move, but also saying that it really needed to be kind of fleshed out and implemented through, among other things, an agreement between DOJ and HHS or CMS that, or excuse me, the SBA, that would, where DOJ would say, we're not going to bring False Claims Act cases against lenders for relying for approving loans based on these certifications without consulting with the SBA. And also, we will move to dismiss key TAMs that are brought against lenders, based on their processing based on these certifications and applications, pursuant to we call them the Granston motions to dismiss False Claims Act cases that are contrary to public programs and public purposes. So these are remarkable moves, but they are, as you said, they're limited to the PPP program part of this huge effort that's ongoing.
Thank you, Bob. Well, what I would flag, and this goes outside of the scope of the False Claims Act, but I've already seen class action lawsuits getting filed against Wells Fargo, Bank of America, and other financial institutions alleging state consumer law or consumer fraud or unfair and deceptive practices violations, like in California, because the lender didn't allocate a significant amount of funding to small businesses, but to larger businesses. And that happened within a matter of a week after the program was getting administered. And so that's clearly not in the False Claims Act arena, but I think it gives you a flavor about the litigation concerns about engaging with this program that is so vitally important to keep businesses sustained as everybody's shutting down. As things are moving forward with some openings here and there, but clearly there are some concerns on that front. Would you agree, Bob, or is that something that we shouldn't worry about?
No, I would agree. And by the way, I think it's a little too early to say that it's not in the False Claims Act arena because, as you know, any False Claims Act allegations would have to be filed under seal. So even if a suit went forward on other grounds that don't have to be filed under seal, like the state, consumer protection statutes, there could be allegations either in the making or that have already been brought that would basically say that in allegedly discriminating among buyers, the banks were violating a express or implicit requirement of the PPP and therefore were causing false claims to be made. But wholly apart from that point, Harold, you're absolutely right that the hold harmless provision in the SBA regs is not a total, walk away. There are aspects where these issues are going to still have to be fought out.
So, Bob, what would you recommend in terms of solutions to at least give some certainty to the lenders as they engage with the second round of funding that Congress just authorized? There are going to be more loans in the coming days and weeks. What could be done from a legislative but also administrative level to offer that type of security and certainty?
I think it's going to be administrative, I think, and it's probably going to be along the lines of the comments. There has to be some agreement by DOJ, whether it's in the form of a policy statement in the Justice Manual or an agreement with SBA or other agencies that they will not use the False Claims Act in these conditions, and they will move to dismiss suits brought by key TAM relators who do. As to the California consumer protection kind of things, I think that's more in John's bailiwick. I don't think the Justice Department in a False Claims Act memo can do too much about that.
Well, I think that we could have an ILR Briefly event just about California in and of itself, but we'll save that for a later day. Since you mentioned John, why don't we turn to John Beisner? John, what I'd like to talk about and start a discussion about are the four core areas of liability concerns that I mentioned earlier during my remarks. Let me start with what I describe as one of the bigger ticket items, and that is exposure liability claims. We've certainly heard quite a bit of concern about businesses opening up and finding negligence claims or other related claims when it comes to allegedly exposing their employees or consumers or third parties to the coronavirus, and what was the appropriate standard of care. And I know that we've talked quite a bit about this and thought out some really good solutions. So, John, maybe you could talk a little bit about where you think the problem is. Maybe add some more dimension to it, but also how you think the solution fits into this when it comes to what Congress can do.
Well, Harold, let me start with the point about this. I was distressed this morning to see in the media a number of people commenting that why is anybody worried about who would bring these sorts of lawsuits? Because the causation dimension of exposure lawsuits is so difficult to prove. And they're right. It would be very difficult to prove, to say that an individual caught coronavirus because of a particular exposure, a visit to a particular store or other sort of exposure, particularly given the long period it takes potentially for the disease to develop. But if you step back and think about it, anybody who brings a lawsuit like this is going to have a very sympathetic case. You're going to have an individual who went through a very traumatic health experience, maybe a lawsuit by a family on behalf of someone who succumbed to the disease. And so it's going to be a very sympathetic case. And I think there are a lot of plaintiffs' lawyers who know that there are some courts that aren't going to preclude scientific evidence that is junk science. There will be some cases that will be brought where somebody will bring forward an expert who will say, oh no, I figured this out, and I know that this person contracted the disease because of a particular exposure at this hour at a certain store on this date. And even though that's ludicrous, it'll be allowed to go before a jury. And so I think the idea that these lawsuits won't come unless some protection is provided, I think it's just ludicrous, even though the lawsuits make no sense. Harold, I think the right approach to this is to take a page from what has been done in some other contexts, and that is to provide some protection to businesses that either remained open as usually as essential businesses during the crisis to provide an important service to the public, and those that will be reopening now, based on the premise that they should be afforded some protection if they generally complied with the guidance that's been provided by the CDC and by state and local authorities. And if they did that and observed that guidance, then they should be afforded some protection. There should be an exception, as we've seen in other legislation and directives of this sort, that would provide some window there in the event that the particular business engaged in egregious behavior that may make the protection illogical. So that sort of exception should be in legislation of this sort. But I do think that legislation is needed to provide this sort of protection, or the courts are going to be flooded and businesses are going to be really faced with an enormous burden of dealing with these lawsuits. And I think a tidal wave of those cases will come unless some sort of protection of this sort is provided.
Thank you, John. The one question that I wanted to ask you about is, how does our proposed legislation, again, which would create a safe harbor for employers who follow CDC or state or local guidelines, how would that affect the employer-employee relation, specifically in the context of workers' compensation?
I think the key thing to keep in mind here is that this legislation is really focused on litigation, that is court lawsuits that are filed. I don't think there's any intent here to interfere with the workers' compensation process, which is in states administered through administrative agency processes. And so that would be preserved under the legislation that I think is being contemplated at this point. This is really focused on litigation against businesses outside those administrative processes.
And John, you made an interesting point about causation, because we hear a lot about, gosh, how do you prove causation under traditional negligence principles. But one of the things that we flagged as a concern is the potential rise of public nuisance claims, which, as many of you know, including John, you don't need to show causation. You just need to show that you caused a nuisance and that somehow you need to pay into some sort of an abatement fund. John, I'm wondering if you've given this issue some thought and whether it's something that we should be watching out for.
Well, it's worrisome. I think that such lawsuits would be well beyond the appropriate scope of public nuisance litigation, but we've seen some courts accept migration beyond those fundamental principles in recent years. So it's an appropriate concern, and I can see the possibility of some plaintiffs' counsel taking that approach of going in and saying, you know, this store opened and they invited customers in to buy groceries or whatever it may be, and that was a public nuisance, and therefore substantial damages should be paid for that. There's a lot of issues I've got with how that would all work and who the claimants would be and where the money would go and so on, but someone will probably take that initiative unless some protective legislation is enacted as a way to skirt those causation issues.
Thank you, John. Why don't we turn to the second area of liability concern, and that is product liability. Bob, I'm going to field this over to you. As many of our viewers may know, the Federal PREP Act, PREP, was passed in the wake of Hurricane Katrina, and it was enacted to protect manufacturers of emergency countermeasures and the people that deploy them from civil liability linked to those products. The PREP Act was recently amended as part of the Cures Act, which I mentioned earlier, to include additional protective equipment in addition to volunteer healthcare workers. We are looking to actually encourage the increased scope and reach of the liability protections from the PREP Act to other product manufacturers, also in the context of manufacturers who are voluntarily contributing PPE to hospitals and to the front line. And so we do think that the liability protections currently offered under PREP should be expanded. We've been talking to Bob about this. The paper will address this, but Bob, can you elaborate a little more about the problem in addition to the solutions?
Sure, thanks. So I think the three areas of focus in PREP are on the three key terms in the statute. One is covered persons. Who's a covered person? You mentioned some of the people that were already covered in the statute, but it doesn't include everybody who is affected by this crisis. People, for example, who are building ventilators or other kinds of medical devices and donating them to the government. End users and employers, for example, are not currently defined as covered persons. The second term, and I'll come back to that in a sec, but the second term is covered countermeasures, which are the actual products or the components of the products that have this immunity that's given by PREP. And then finally, there's a nexus requirement in the statute. There has to be a nexus to government action of some kind, either a government agreement like a contract or a grant or some form of arrangement, or that the actions being taken pursuant to a declaration or an order of a designated authority. I can't remember the exact term, but something close to that. So that's an area that needs some work as well. There's a fourth point, which is that there is an exclusion from the immunity for someone who engages in intentional misconduct, but I don't think that is pretty well defined. And the immunity of the statute is therefore pretty broad. So I don't think we're talking about working on that part of the statute, but on the covered persons, there are proposals to either legislatively or administratively expand the covered persons to include people who donate, end users and or employers. On the covered countermeasures, As you said, the act, I think added respirators, masks, but there are other products that need to be brought in as well. And on the nexus, there's some ambiguities that probably need to be clarified either in the Secretary of Health, HHS's declaration, or in the statute about what exactly is the nexus of the product to the federal government. Does there have to be a contract, or is it enough that it's FDA approved for any purpose, or does it have to be under some sort of emergency use authorization as well as being FDA approved?
Thank you, Bob. John, what say you?
Well, I don't have much to add to what Bob just reported. I would note that HHS was out front on this with its actions early. But in talking to those that are intensively working with these issues, the practitioners in this area, I do know that, as Bob was outlining, clarifications are needed. And I think it is providing a lot of uncertainty at the moment among those who are critically needed to be wholeheartedly devoted to working to fight the virus and provide equipment and other countermeasures to deal with that issue. And so I think all I can add is that there is attention is needed to this because it is causing some significant problem in various companies coming to grips with the liability risks in this area.
Thank you, John. I mean, it seems like things are moving so quickly. I mean, you look at companies that are now repurposing. Distilleries in Kentucky are now manufacturing hand sanitizer, and auto companies are manufacturing ventilators. And so things are moving at a rapid rate, and it happens so quickly that the liability concerns could get outpaced by the innovation and by the response to the coronavirus. So all things that we know are of critical importance to a lot of our members, but also for the business community. Let's move on to the third bucket area, and that's securities litigation. Look, our stock markets, our capital markets have taken absolute beating. And it is clear to see a scenario where disgruntled investors, encouraged by plaintiff lawyers, especially in the class action securities bar, will try and capitalize on this. We've already talked about the lead up to class action securities litigation abuses, which have really hit an uptick over the course of the past several years. But we know that you can concoct any type of theory of liability, especially in the occurrence-based securities lawsuit, when it comes to how companies responded to the coronavirus, or did they take voluntary actions that had an effect on their stock price. So we have made some proposals that would at least curb the abusive nature of class action securities litigation that we can see emanating through the wake of this. And John, I'm wondering if you could talk a little bit about the problem, but also the solutions.
Harold, I think a lot of the problems that we're likely to see in that area are really extensions of what you talked about in last, you referenced a few minutes ago, and I would urge people to take a look at that because I think it really outlines the problems that we're likely to see, but they will be magnified by the coronavirus environment. I think the two areas of greatest concern in this area will be securities class actions that may be brought alleging misrepresentations or omissions regarding the impact of COVID-19 on business operations and profitability. This is a real challenge at the moment, is to look ahead and provide information about company expectations in terms of revenues, profits, and so on in an extremely unpredictable environment. And I think that we will see practitioners out there trying to take advantage of the uncertainties there and try to pick apart technical aspects of statements that may be made in that regard. I also think we may see some lawsuits targeting alleged false claims about the capacity of products that are in the pipeline or that have actually been put on the market to address the coronavirus. This is going to be an issue because, as we become to understand the virus more fully, some representations that may be made at some point may prove to be less valid as the science of this evolves. But I do think that we will see some lawsuits making allegations about the accuracy of product descriptions and representations about capacity. You know, I have seen several articles in which securities class action practitioners have said they're biding their time, waiting to see how things turn out a bit more. I think what they're actually saying is they're waiting to see what, from their perspective, the lowest hanging fruit may be, as opposed to taking a cautious approach to all of this. But there definitely will be litigation filed in this arena, and probably calling out for some of the reforms that you were just mentioning.
You know, John, we've been talking to the administration, but also with state level executive agencies about what can be done administratively short of the legislative process. And I'm wondering if you have any particular thoughts in the securities litigation context as to what the SEC could do.
Well, as in so many of the other areas we're talking about, as I think Bob was highlighting earlier, part of the problem is that there are private causes of action that may be brought on these issues, and the administrative agencies are hamstrung to, I think, preclude such actions. But, you know, they could be active in the litigation with the filing of amicus briefs and things of that sort, to really raise questions about the validity of these claims, particularly given the very tumultuous environment in which the actions that may be challenged were taken.
Thanks, John. Let's move on to the final, or the fourth core area of concern, and that's medical liability. This is specifically focused on those who are protecting us and those who should be protected from lawsuits. We've seen a bevy of activity on this front from the states, from governors in places like New York, Illinois, and Michigan, but also state legislatures as well. And this is something that we've certainly identified as an important area of liability protection, given the state of affairs with how healthcare is responding to this current pandemic. So, John, I'm wondering if you could elaborate a little bit for us on that front.
Harold, in this area, we do have somewhat more of a blueprint to work with because, as you noted, a number of states have taken action in this regard. Governor Cuomo, in particular in New York, was out front early with executive orders that provided protection for volunteers, for example, who were providing assistance with healthcare, and that's expanded there and in other jurisdictions to provide protection to both individuals, doctors, healthcare providers who were assisting in these efforts, but also to the institutions, the hospitals and the clinics that have been very much involved in providing this care. And so I think what is needed here is protection for these individuals and institutions that will ensure that they are not subjected to an enormous amount of litigation challenging them under sort of normal malpractice standards, and that it really be a situation where if egregious behavior is identified, perhaps actions could be brought, but limiting the ability of actions to be brought against them under the much lower standards of negligence, as you may see in a malpractice action of various sorts. I mean, I think all of us have seen enough in the media reports about the duress under which both the practitioners and the hospitals have been operating over the past month, to understand that normal procedures have not been followed in all instances here. They couldn't be. They didn't have capacity to take the time to make the decisions, to dot every I, to cross every T, to deal with all the regulatory requirements and so on in certain circumstances, and had to make decisions somewhat more, I hate to say it, but on the fly than they normally would have been. And so I think that some protection needs to be provided in this circumstance, both for what has happened already and what is likely to continue happening as the healthcare arena deals with the pandemic.
Thank you, John. One of the questions I wanted to ask you is when we talk about the four areas, the product liability piece and the securities litigation piece are, from a legislative point of view, are amendments to federal law. But when it comes to the exposure liability piece of it and the medical liability, fundamentally, you are displacing state common law tort or negligence claims. And I'm wondering if you could talk a little bit about Congress's authority to enact these types of reforms and how that rub is going to happen when it comes to either 10th Amendment concerns under the Constitution or, whether this does implicate interstate commerce under the Commerce Clause.
Well, this sort of question has been raised when we've had other legislation that arguably impacts state law in the liability, particularly the product liability arena. This question was raised frequently when work was going on with respect to the Class Action Fairness Act, for example, that you referenced at the top of the program. I think it's just very hard to make a plausible argument that what we're dealing with here isn't an interstate issue. This is a federal issue. To be sure, a lot of the ramifications are occurring at the state level, but this is an area where a nationwide response is needed to this issue. And I think it would be very difficult to construct an argument that what we're talking about here doesn't have interstate implications. I mean, I could go off and spend the day conjuring up a hypothetical, I suspect, saying that, that as applied, this legislation, doesn't really implicate interstate commerce in a particular setting. But I think to say that particularly given the nature of the response to this, in which there has been so much federal and state interaction in dealing with this crisis, that this doesn't have the sort of interstate ramifications that would fully justify the federal legislation that we're talking about. Well,
as far as I recall, there was a constitutional challenge to the Class Action Fairness Act, but that kind of went down in flames, and that's been a law on the books for decades now. So, gentlemen, thank you very much for the conversation. I think we're going to turn this to the Q&A part of this. Again, as a reminder for our viewers and for our listeners, the chat bar to your right should offer you an opportunity to type in questions that we will moderate and have a designation for answers. So let me start out with a question that came in. This is probably for you, John Beisner. Do you think a minimal diversity concept similar to the Class Action Fairness Act would be helpful in the COVID liability space?
I do think that would be helpful. I think you need to think about what types of claims would be covered by that. But I do think it would be useful to have these cases in federal court as much as possible. As I said in response to your last question, this really is a federal issue, and I think that having these matters presented in federal court for the most part would allow one judicial system to manage these claims as efficiently as possible. There may be instances where use of the multi-district litigation system would be a way to accommodate some types of claims that would be brought. Certainly not suggesting that all COVID-19 claims be put in one proceeding, but there may be certain types that would be susceptible to coordination. But I also just think consistency within the federal court system in making judgment about these claims, particularly if we have the protective legislation that we've just been talking about enacted, I think having them in federal court would be very useful.
Thank you, John. I'm going to kick the next question over to Bob, which is False Claims Act related. I think that you've answered some of it, and so I'll go on to the back end of this question, and that is, do you think that most of the litigation in this space being the False Claims Act, is going to be a DOJ lead, or will there be more qui tam-based litigation? This is obviously litigation brought separately under seal by whistleblowers before the Department of Justice gets involved.
My gut is that it will be qui tam driven, that it'll be the private enforcement driven, just because the current DOJ has been very solicitous of not bringing cases that would be contrary to program purposes, particularly in the healthcare area, and have moved to dismiss well over 30 cases brought by relators that would have had that effect. So my gut is that it will be qui tam plaintiffs' lawyers who will be driving the train on the COVID-19 related FCA stuff, other than, the out and out scams, people saying, oh, I have a cure for it, or, some other, or I have a gazillion ventilators, just send your money here, that kind of stuff. DOJ, I think, will take the lead in. But the more, and I wanted to follow up on something that John said, particularly in the healthcare area, moving away from lenders and PPP and stuff, but in healthcare providers who are, or even insurance companies who are dealing with these, the reimbursement and the federal funds of all of this treatment we've been talking about and prevention. Because of the need for expediency, you're going to have the situation where not every internal procedure or even control is complied with because the time isn't there. And that has been the basis for so many qui tams in the healthcare area. You didn't comply with this plan or this process or this requirement, one of the many, many Medicare requirements, and therefore your claims are false. So I think we can see that. And one other point, Harold, to make real quickly, is that we have a new player in the False Claims Act area, as you know, which are third-party funders of qui tams. And so not only do we have relators and relators counsel looking to, hate to use the word capitalize, on the situation in terms of the False Claims Act, but you also have an industry now who is big and who has gotten involved in False Claims Act qui tams.
Well, Bob, let me stay on that topic a little bit and kick it over to John. This is kind of like a tennis match here, but as we talk about third-party litigation funders, and if you are on this video and you don't know who a third-party litigation funder is, these are financial outfits, hedge funds that are actively investing in litigation through direct funding with law firms. We're particularly concerned in the area of mass torts and class actions, qui tam, and it certainly goes beyond what we have traditionally known on the plaintiff side when it comes to funding from the contingency fee driven arena. But John, I'm wondering if you could just speak generally to the litigation funders and how they're currently preparing or not preparing for what's happening in the wake of the COVID-19 epidemic or pandemic, and the potential litigation and the opportunities that they might have.
Oh, I think it's gone beyond preparation. I think that the funders are in full implementation mode at this point. We've seen a flood of articles, both written by funders and quotations from funders and other articles, basically saying to the legal industry, which like other businesses is cash strapped in some respects at the moment, or at least worried about cash flow, saying, we've got lots of cash, come to us. And really what they're saying is, come to us and get some money quickly in exchange for taking on various types of litigation, even litigation in an area in which the firm at issue may not have participated previously. I can't say that it's been focused on saying to law firms, you ought to bring COVID-19 actions, but I think that's implicit because that's going to be where the plaintiff's bar is focused at this point. The interesting part, I guess, I have seen in those pitches from the industry, though, has been a lot of it has been focused to what have been traditionally defense firms, and impliedly suggesting that some of them should be looking at moving over to the plaintiff side and perhaps look at bringing some of these COVID-19 actions, whether they're in the false claims arena or perhaps securities, other areas that we've talked about. I think it remains to be seen if that pitch succeeds, but I think impliedly it's there, and we've been seeing a lot of press from the litigation funders, basically with the happy days are here again theme, that if you need cash, they're the place to go.
Thank you, John. I appreciate your response on that. I know that we're past our designated time by a few minutes, so let's just do a couple of more questions. We have one that is non-anonymous, coming from Paul Martino from the National Retail Federation. Is the intent of the exposure liability protection to cover claims of all parties, employees, consumers, service providers, and shipping/trucking personnel that are on a business's premises? Paul, I think I could respond directly to that, and the answer is yes. We are trying to keep this as broad as possible so that there is an established standard of care for any business, any employer. Certainly the employer-employee context is covered to the extent that it doesn't reach into workers' compensation, as I had discussed earlier with John, but also it should go beyond essential and non-essential businesses. Certainly those businesses that are currently in operation is one segment of that population in the business community, but the larger piece of it will be all these other businesses. So the answer to your question is yes, and we do appreciate your joining on this call. Maybe one more question. Let's see here. John, maybe I'll direct this to you. What is a reasonable and recommended window of protection? This is a good question. Should it be triggered by a governor's declaration of a state of emergency, or should protection start earlier than that, i.e. prior to the issuance of a formal executive order? I guess what I'll just say on that is on many of our proposals, we think that there has to be a reach back to causes of action from, I think the effective date of most of our legislative proposals is December of 2019. But John, I'll also get your take on that as well.
No, I think there does need to be a reach back, as you're suggesting, Harold, because I think that we're beginning to see some evidence out there of coronavirus being in the United States earlier than we thought, at levels that we didn't originally understand. And I think there does need to be this protection in that time frame as well for business, because we're just going to have this onslaught of actions. Even though nobody knew at those stages what the coronavirus was. I think we often forget how late it was before the WHO and others officially said, yes, it's a communicable disease. And I think a lot of that timeline, the evolution of our understanding of the disease will be forgotten in this context. So yes, I do think the start date for this needs to be early, and perhaps before any sort of formal governmental action was taken to declare this to be an emergency situation due to the pandemic circumstances.
John, thank you very much. As always, your answers are lucid and crisp. In addition to you, Bob, appreciate you guys getting on today for this second ILR Briefly event. I hope that our visitors have taken away at least some substance, some interesting insight in terms of the conversation we just had. As I mentioned at the beginning of this program, we will be issuing our official research paper as early as tomorrow, and we'll make sure that we send you a special link to the paper for everybody who has RSVP'd on this call. Just a quick reminder that our next Briefly event, I believe, is on May 6th, and I don't think we'll have research associated with this event, but it's going to be with the Deputy Attorney General, Jeff Rosen. It's going to be very interesting to hear what the department's response has been in the wake of COVID-19. Certainly, they are very focused on counterfeiting and price gouging and fraud. whether it's with the CARES Act or with other federal programs. So it'll be interesting to hear his insights, and we would welcome the participation from folks, either chamber members, other industry-specific trades, for a very interesting discussion to be had. So with that, thank you again for your participation. I want to thank Bob and John. You guys were terrific. Thanks to Oriana Senator, our head of research, who put all of this together, and to the fine chamber team that makes all of this technical stuff work, because it is very complicated, as you might imagine, to have all of these slides and to do this remotely, but we're getting better at it. I even have a backstop here, so I kind of rolled this out for the very first time. I hope it doesn't look too bad. Would love your feedback. Stay safe, stay well, and we'll be in touch. Take care.